Okay, welcome. Good morning, afternoon to you, ladies and gentlemen, wherever you are. Greetings from London, greetings from Chatham House. I am really pleased to announce today's event on transitional justice. What might it look like? It's quite a special week for Chatham House and for Ukraine Forum. Chatham House is celebrating this week its 100th anniversary since the think tank was established in 1920 in the aftermath of the First World War, with this very noble goal to help government and society build sustainably secure, prosperous and just world. So it's no coincidence that we are discussing about justice, transitional justice, for Ukraine, for Ukrainians at the times when the country was a victim of a quite blatant aggression and annexation from its neighbor, Russian Federation. So transitional justice, of course, is perhaps familiar to many of you, but perhaps new to some, because our audience includes also regional experts and not necessarily international lawyers. But just to set a context, by transitional justice, we mean judicial and non-judicial measures implemented in order to redress legacies of human rights abuses. So we will be discussing some of the key pillars of transitional justice. Our event is on the record, ladies and gentlemen. We will also be releasing a recording of this discussion after the event. So we will, of course, look at the capacity of Ukraine to implement transitional justice, at the quality of justice as such, how to unify different initiatives, and what is missing in this nascent roadmap of transitional justice that Ukraine is trying to develop. But before I introduce our speakers and give them a floor, I would like to set a bit of a context, of course. Whereas the armed conflict in the east of Ukraine, in the parts of Donbass, is still ongoing, despite over 20 commitments by the Russian Federation to ceasefire. There's still no ceasefire, unfortunately, and Ukrainian servicemen and civilians are suffering. Overall, this conflict is now in the 7th year, and the toll and the cost on the country is substantial. Of course, there is, as I said, a human cost, there is economic cost, but also there's grave human rights abuses, and they range from, you know, extrajudicial executions to torture, to enforced disappearances, many things that we will be discussing today. And this conflict reverberates not just, you know, in the annexed Crimea and parts of occupied Donbass, but throughout Ukraine. So with me today, I have an excellent group of professionals, practitioners who are familiar with this international human rights law, humanitarian law, conflicts, and I will introduce them in the order they will be speaking. The first one will be Kirsty Brimlow, who is the barrister at Doughty Street Chambers. She's also the head of the International Human Rights Team and member of Wellness and Diversity Committee. Very important for us and for the audience today is to learn from Kirsty about her experience as an accredited mediator in various conflicts, especially her work with the mediation in Colombia, where she helped in 2013 to facilitate an apology to a community impacted by the conflict from the President Santos. And this was a historic moment. So Kirsty will give us lessons learned, an overview from other parts of the world affected by conflict. Then she'll be followed by Anton Koronevich, who is the permanent representative of the President of Ukraine for Crimea. This is a newly created position from June 2019, and Anton is really leading the work of the working group on the reintegration of the temporary occupied territories as part of the Legal Reform Commission under the President of Ukraine. There's a group of experts, including civil society. And last but not least, Taras Tsimbrivsky, who is human rights defender specializing in international human rights and international humanitarian law. He is managing USAID-funded Human Rights in Action program that is implemented by the Ukrainian Helsinki Human Rights Union. So you see, we have an international expertise, Ukrainian policymaking, civil society. So let's make a head-on. Kirsty, I would like to pass the floor to you.
Thank you very much, and thank you for the introduction. I'm going to speak about the mediation that I conducted in Colombia, first of all, and then give an overview on the peace process in Colombia. So I was in Colombia in 2012 when I met a community called San Jose de Apartado Peace Community. And they're a community of cacao farmers who in Urabá, in the northeast of Colombia. And they consist of around 1,000 people. They set up their own space in 1997 with rules which included that they were not going to get involved in Colombia's conflict between the state and the FARC. And they had rules such as no weapons, no drugs, no alcohol, and hence they really had their own framework of peace, but on a micro level. They subsequently found themselves, as many of the campesinos have and still have in the past and are still in the position now, in a situation of being in the middle. And they suffered immensely with over 260, about 264 of them have been murdered from that community. The particular massacre that caused the community to break off all communication with the Colombian state was on the 21st of February 2005. And those killings included the leader of the peace community. And also there were 7 people killed by responsibility was laid at paramilitaries in collaboration with the Colombian army, with some very low-level army members eventually convicted. But the 7 who were killed included 3 children, one of whom was only some 18 months old. And they still have the memory of those who were murdered, which they commemorate every year. In 2012, I found myself in a position, because I was then head of the BAR's Human Rights Committee of England and Wales. And I found myself in a position where I developed a relationship with the community, but also in my position as head of the BAR Human Rights Committee, I developed a good relationship with the Colombian ambassador to the UK, Mauricio Rodriguez. And we became friends, and we're still friends now. And he had a very different approach to diplomacy to that I'd come across in many other parts of the world, in that it was practical. And he wanted to assist me to see if we could bring some reconciliation between San Jose de Apartado and the Colombian government. And at this time, President Santos was on a path to achieve a very big goal of ending the 52-year conflict which had been running in Colombia. And it still remains the longest running civil conflict in the Western Hemisphere. It was at that time since around 1958, 1954, depending which dates you take. So I found myself in a position where I had meetings with the president and also with the Vice Minister of the Defense and the peace community. The highlight of it was an apology from President Santos to the peace community on the 10th of December, International Human Rights Day, 2013. And he asked for forgiveness, not only on behalf of the state, but also he asked a sort of personal forgiveness to these farmers. And in that recognition of the need to ask for forgiveness was also a recognition that the farmers were not FARC. They were often accused of being, in fact, part of the FARC or terrorists, and they have been publicly denounced on many occasions. And he recognized them as in his words, the president said, a courageous vindication of the rights of Colombians that, despite having experienced the conflict firsthand, has persisted in its efforts to achieve peace for the country. And he said, for me as President of the Republic, I have only profound admiration and respect for the peace community, and I regret and rebuke all the past accusations which have been made against its good name. So that was a significant building block to creating peace with a community which had become very emblematic in Colombia. However, it was complicated in that the community initially rejected the apology from the president, partly, in my view, because they never thought it would happen, and they'd been let down many times before. But eventually they did publicly accept the apology. Their current situation is that they are struggling with the vacuum left in the area where they live, the vacuum left by the withdrawal of the FARC and the infiltration now of paramilitary groups, armed groups, drug traffickers, all fighting once again for the land of the campesinos. And killings have sadly increased in that area post the signing of the peace agreement. Very briefly on the peace agreement itself. Well, Colombia is the third most populous country in Latin America. It's a population of about 49 million people. And the conflict, the internal conflict, has taken around 220,000 lives. And that's according to the government-created National Center for Historical Memory. So likely to be much more. The internal displacement of people is the highest in the world and currently set at around 7.7 million displaced since 1985. The peace agreement that was reached, I was at the signing of it on the 24th of August 2016 between the FARC leader whose nom de guerre is Timochenko and President Santos. It fell into 6 agenda items, and they are comprehensive rural reform, so that is to strengthen the state's presence in the country, plus there is a land fund of 3 million hectares at its disposal for 10 years, and this includes lands which have been taken unduly, unlawfully appropriated and occupied. There's a national plan to reduce poverty over 10 years by 50%. There's also a victims law which has been in place since 2011 to restore land, but this has moved slowly. Another phase is political participation, that there's an increased political access to leaders of social movements and advocates for human rights. And this included designated seats to former members of the FARC. There's a laying down of arms, and there was a verification process carried out by the UN, and a relocation of the FARC into transitional local zones, which have been problematic as to how they've been constructed. The political party that emerged out of the FARC had a contribution to its operational costs and a guarantee of 5 seats. Timochenko faultingly ran for a position, but withdrew in 2018 through a combination of issues, including security. There are various commissions to provide protection to all Colombians. However, this is an ongoing issue within Colombia. There is a Truth, Coexistence and Non-Repetition Commission, which is a fact-finding as to what has happened, including a special unit for the search for missing persons. And importantly, there is a special court, the Jurisdicción Especial para la Paz, the HEP. And that consists of 3 chambers with 18 magistrates and 6 amicus. The judges are selected from the Colombian Supreme Court, the UN, the International Center of transitional justice, they're selected by these various organs, and they cover a range of what could be said to be political viewpoints. They have a caseload of investigating approximately 9,734 former FARC members, 2,640 army, 96 state officials, and there are more than 900 third parties who are applying to be part of the process. In summary, there are two branches. One is for recognition and responsibility. And there are sentences, if there's an acceptance of responsibility, means that no prison will be passed, and sentences of 5 to 8 years, which are effective restrictions on freedoms and rights, in addition to an obligation to carry out community work. The second branch is the investigative and accusation unit. That is the hammer, in that if responsibility is not accepted and guilt is found, then prison sentences of between 15 to 20 years can be passed. All of this is in the shadow of the ICC and the Rome Statute, which means there cannot be amnesty for grave crimes. Just finally, in the time to conclude, this tribunal, the HEP, is very important. It follows on from the South African Truth and Reconciliation Commission, but post the Rome Statute in 1998. Variants of the South African Truth Commission grew up around South America, in Guatemala, El Salvador, with Peru having the first public hearings in 2003. But this tribunal in Colombia is very much one which the world is watching to see how effective it is and how successful it is. The current huge challenges are security and witness protection and fear of participation. There are around 303 murders of social leaders which have occurred since the 2016 peace accord, and also there have been a high level of killings of former members of the FARC. And so 173 is the figure, the most recent figure from the UN mission on the killings of the FARC. And so the longevity of the HEP, which is set in place for 15 years under the Constitutional Court now, is always one which is delicately balanced. Thank you very much.
Thank you very much, Kirsty. I think you gave us an excellent overview of the infrastructure, so to say, of transitional justice, from apologies and never repeats kind of steps that could be taken, to a very concrete special court that is set up to investigate grave crimes against human rights and violations. And of course, Ukraine is only making its first steps in this direction. It's part of President Zelensky's strategy to bring peace to Ukraine. And Anton and his team are in charge of shaping, really making just some of the important steps in shaping these pillars of transitional justice. So I'll now turn to Anton to give us an update how Ukraine, what kind of key components Ukraine sees as part of its transitional justice, and what has been achieved to date. It's been only a year, right, since the working group was set up to work on this transitional justice policy, but also where do you see, the risks and obstacles to progress on delivering justice to, millions of Ukrainians who have suffered from loss of buildings, displacements, and abuse. Anton, over to you.
Thank you very much, Orisa. Good afternoon to everybody, or good morning. I'm really glad to participate in this event today. So many thanks for Ukraine Forum Chatham House for organizing and for co-hosting this event, and we, in the mission of the President of Ukraine in the Autonomous Republic of Crimea, are very happy to be co-hosts of this roundtable. As Orisia said, a year ago, in August 2019, the new Commission on Legal Reform under the President of Ukraine was established. Inside this commission, there are several working groups with several different tasks. And one of these working groups is the working group on reintegration of temporarily occupied territories, to which I'm a head of. And this working group consists of experts from different fields. We have experts from academia, from governmental agencies, from law enforcement agencies, and of course from NGOs, from civil sector. So I would say that one of the issues which we are to discuss today, the cooperation of the governmental officials, government agencies with the NGOs, with civil society organizations. So our working group is actually the good example of such cooperation, because we do have a lot of representatives of NGOs inside. So because we do believe that drafting a transitional justice model for Ukraine is a common thing for governmental officials and for experts from civil society. Our working group has started to work with this key issue of drafting the model for transitional justice for Ukraine. So this is the main task which was set for us by the President of Ukraine, Volodymyr Zelensky. And we are now very close to finalizing the job. We are very close to implementing the feedback which we got from the Office of the President, from the governmental agencies, from civil society, from international partners with whom we also worked on this piece of work. So we do hope that rather soon we will pass this ball, we will give the concept for the consideration to the Office of the President. There are key issues which I would like to mention about the concept, about the model. As of now, we do think that this concept may have the form of the decree of the President of Ukraine. And this, we believe, may be a good form for it because of its a rather framework document. So this is not a document which can answer all the questions. This is a roadmap to implement which there should be adopted the laws of Ukraine, the decrees, the regulations of the Cabinet of Ministers. So this is only the start of a big road. So this is a real roadmap. On the other hand, there are several important issues which are set forth in this concept, which we do believe are of paramount importance. First of all, we do apply this concept both for situations in Crimea and Donbass. So I think that this is one of the key issues which maybe sometimes in the press, in the media, maybe a little bit misunderstandings that transitional justice may be applied only to Donbass because there are hostilities there. For us, this is not so. For us, transitional justice model should be applied both for Crimea and Donbass, as Crimea is international armed conflict, is occupation, and we do not divide these issues in the concept. The second issue which is important is that we strictly say in the concept that there is an armed conflict on the territory of Ukraine, which is caused by the aggression of the Russian Federation, and that this armed conflict is the international one. So we do believe that this is very important because we also need to talk about the role of the Russian Federation. Russian Federation is a state, is the aggressor state, is the occupying power both in Crimea and in Donbass. Yes, there is some difference, like in Crimea, they do the job with their own hands. In Donbass, they do the occupation by proxy with the help of this so-called anti-governmental organized armed forces. But anyway, we do believe that there is no other ways to qualify the situation and to talk about the Russian Federation. The concept itself also gives some background for the law enforcement agencies to understand on which crimes they may work and which crimes cannot be amnesty for or pardoning for. Let's say the concept strictly says that for the commission of war crimes, for the commission of crimes against humanity, there can be no amnesty, there can be no pardoning. So the persons who are accused of committing these crimes should be brought to responsibility. The same goes for the criminal responsibility for the people who had top positions inside the occupation administrations, so who themselves were in charge of either commission of war crimes and crimes against humanity or commission of crimes against the sovereignty and territorial integrity. On the other hand, it is important, I think, to understand that the concept as a rather framework document does not include the direct catalog who will be brought to responsibility and who will not. We do believe that this can be regulated only by law, and we do think that the law shall be adopted in order to implement the concept, and this law should be a very direct one, which will say which categories may be brought to responsibility and which not. But these general issues like about war crimes or top officials of occupation administration, we believe that that should be here in this transitional justice concept. So these are these pillars, I would say, which are there. Of course, our transitional justice concept or model for Ukraine is based on the best international approaches and best international practice. We collected the approaches and experience and looked at different experiences all over the world. So it includes all these four basic elements or four basic pillars of transitional justice applied worldwide, namely responsibility for grave crimes, namely the reciprocity of damages caused for the civilians, for the population, also the institutional reforms in order not to let the conflict begin again, and also, of course, the issue of truth finding, of establishing the historical truth. So talking about these four pillars, they all are there in the concept. And we do now work on the issue of communication of this concept to the society. We do believe that this is a very important issue, how to rightly, in a proper way, communicate transitional justice concept for Ukrainian society. Because we do see that transitional justice issues are very new to Ukrainians, both for politicians, experts, lawyers, journalists. So they do now know what is transitional justice. But when we open this transitional justice book, we need to do it in a way not to have misunderstandings and for the key stakeholders to understand what we do anticipate to see in this transitional justice book for Ukraine. So this is why we now work on the communication strategy, because we do believe it is very important in a proper way to communicate these messages. This is why, while we were working on the transitional justice model for Ukraine, we consulted with pretty much all the stakeholders, because we understand that the issue of co-ownership in this question is very important. This transitional justice model shall be known for people who either make policy or who are important stakeholders and who are leaders of thoughts in this area. Because we may not, we cannot have the situation when there will be misunderstandings or high critique without the understanding of the essence. So that is why this co-ownership and this getting of feedback from different professional societies, from different professional spheres, were very important for us. And this is what we were doing actually in this COVID-19 pandemic time. We were getting this feedback and we were consulting with different groups in order to really get the idea, their idea of how this concept should look like. So as of now, of course, the working group on reintegration of temporarily occupied territories of Commission on Legal Reform is primarily responsible to finalize the national transitional justice model for Ukraine. But actually, this is really a co-ownership story. This model is being drafted together with ministries, together with NGOs, together with international partners. That is, law enforcement agencies, of course, very important, working on Crimea and Donbass, because we do feel that when we will make this concept public, it is not public yet. We do know that there were some talks that somebody got the concept, but the concept is not public yet. So we want to make it public when we will have this communication strategy in order to get this publicity in the right way. So we do now have two primarily, let's say, goals when we talk about our transitional justice model for Ukraine. So first of all, we are now finalizing the text, and we hope that rather soon we will pass it to the office of the president in order then for the office to work on it. And of course, we anticipate and we will work hard in order for this concept to be adopted in the form of the decree of the president of Ukraine. And as we do anticipate, this decree can also include the position for the cabinet of ministers to draft the action plan in order to implement this roadmap, this framework, transitional justice concept for Ukraine. So this is our first, let's say, piece of work, finalizing and sending it in order for it to be adopted. Though, of course, we understand that finalizing the text is not the end of the road. Of course, there will be discussions, debate. I'm sure of that, but we are ready for this. We need a result, and we are ready to work for this result. And the second piece of work is, of course, this communication issue. So how to communicate this transitional justice in such model in such a way that Ukrainian society understands the main principles, that Ukrainian society will understand that transitional justice is not about monuments for war criminals, that transitional justice is not about pardonings and amnesties for everybody, everywhere. But of course, that transitional justice includes a lot of issues which deal with reintegration. And of course, in order to reintegrate, of course, there should be some basis for I would say, further reconciliation. So I think I'm done in my 10 minutes. I will be happy and ready to answer the questions if they are. So finalizing, Ukraine is finalizing the national transitional justice model, but this finalizing is now finalizing of the draft text, which we of course understand will still need time and efforts in order for it to be adopted. Thank you.
Thank you very much, Anton. I think you've raised some very important issues, and I would perhaps later, after we finish the presentation, would like to hear some maybe a feedback or advice from Kirsty, especially regarding with the communication, because even the best peace deals can fall apart if they don't have, you know, proper understanding and support in wider society. And here we're also talking about residents, citizens of Ukraine who reside in Crimea or in the occupied Donbass, where Ukraine has very little, you know, in a way, communication capacity because of Russian disinformation and access, you know, to the minds of the people and hearts of the people. But maybe I'm sure this question will come up in a discussion. But now I'd like to give a floor to Taras to feed us in about how civil society assesses this process. Where do you see progress? Where do you see challenges? Taras.
Hello, everyone. First of all, thank you for having me, and thanks a lot for the diligent efforts of Chatham House for keeping this very sensitive and crucial topic on agenda. And let's leave no chances for Ukraine fatigue. Let me also share some reflections on transitional justice policy making in Ukraine, the role of the civil society, and also I will touch upon some broader context, the administration of Zelensky and Poroshenko, what was done in a wrong way or in a better way. So mentioning the very high expectations which Anton Koronevich has mentioned already about transitional justice policy, which is already finished. So I would also like to emphasize that initially the topic of transitional justice, especially when the aggression was ignited back in 2014, it was completely unfamiliar for the wider audience, and a very few experts were very well familiar with this concept. So the key challenge in this field was to push this topic into the wider audience and into the expert audience. And this process was actually steered by the NGOs and the Ukrainian Helsinki Human Rights Union and our partner organizations were steering this process, of course, and we started with the grassroots initiatives. For example, back in 2017, with the help of Donor Society, we convened international conference dedicated to topical issues of transitional justice in order to ignite the discussion and to push the issue further. As a follow-up to this conference, we managed to publish a monography based on the materials of the transitional justice. And the milestone of the process was, of course, 2018, when the work on the future draft bill on transitional justice issues, which should be based on the pillars of transitional justice, was started under the auspices of the Ombudsman's office. So we see that today's efforts, they were started earlier, and it is very important to have an inclusive dialogue between key stakeholders. And this is the civil society, of course, and the state institutions as such. This doesn't mean that back in 2014, 15, 16, Ukrainian government did little in order to address the issues of overcoming the consequences of the armed conflict, but there was no coherent and comprehensive state policy in terms of transitional justice. And this was the key problem which Ukraine was challenged by. And to this end, the administration of Poroshenko prioritized mostly the security dimension, and it was the cornerstone of its policy towards the armed conflict resolution. But afterwards, when the reboot of power took place, when the parliamentary and presidential elections occurred in Ukraine, a bit different stance was taken by the administration of Zelensky. It was like opposite, since at the cornerstone of its policy was the human rights dimension, and the security issues were somewhere in the background. And judging from now, we could see some gradual and limited success, which resulted in some meaningful results, which were absent before. So just to name some of them, I would like to highlight, for example, the reboot of the Minsk process by President Zelensky, who took the leadership in this field. Of course, one of the last examples is the inclusion of IDPs who are residing on the territory of Ukraine. And the other thing, worthwhile thing, is the restoring voting rights for IDPs, which was not the case before as well. Also, the improvement of facilities near the crossing points with non-government controlled areas, proper access to administrative services, which was gradually improved, but not to the full end. Also, the secured access to bank services for the people, for the Crimeans who are residing on the occupied territory. So this is, of course, by no means a comprehensive list of gradual and limited success, as I said before, but still this shows that the strategy taken is a bit better. let's say, and put it in this way, than before. Of course, this doesn't mean that such strategy is flawless as such, since a number of things should be taken in context, and we should view the same situation from different angles. And in my view, there are some drawbacks which should be also mentioned in this context. First, I believe that there was a missed window of opportunities by the current Ukrainian authorities, especially after the reboot of power, since they had everything at their disposal in order to adopt all proper legislation which was burning at that time. For example, it refers to the ratification of the Rome Charter of International Criminal Court. It might also refer to the law on the political prisoners, which was a pressing issue as well. Also, the issue of harmonization of the criminal code of Ukraine with the international standards. For example, up to this date, we do not have the crimes against humanity in the Ukrainian criminal code. This is something unacceptable, of course, and from this perspective, a lot of other things might have been done if we took another stance. Secondly, the communication of the armed conflict by president and its office is somewhat awkward because they are continuously omitting naming Russian Federation as an aggressor state, and this is not changing, and no proper explanation is suggested to the civil society, and it is, of course, irritating issue in terms of the general armed conflict. Thirdly, the statements which are disseminated by our current president and addressed to the president of the Russian Federation, Mr. Putin, are also a bit at odds with the reality. For example, when our president says that Mr. Putin understands our intentions to end conflict, but we should also bear in mind numerous statements publicly made by Russian Federation president, who is trying not only to undermine sovereignty and independence of Ukraine, labeling it as a fascist state or failed state or state which lacks sovereignty. So this is also something which should not be stated in public by the Ukrainian president. Fourth thing, I guess, it is the blurred credibility of Ukrainian authorities, because they have got a blowing victory, 73%, but the afterwards actions which were taken by the Ukrainian government, I mean, on the broader scale, politically motivated persecutions of the ex-president Poroshenko and his allies, which lack credible evidence, and this also entails the persecution of the volunteers who made an immense input into the resilience of Ukraine towards armed conflict. They're also a bit confusing, especially taking into account some gradual advantages which had been achieved so far. First thing, this is the lack of proper engagement of civil society in the resolution of the armed conflict, because, for example, Office of President monopolized this topic and did not let civil society into the process of the conflict resolution. Supposedly, the installment of IDPs into the trilateral contact group is a right move in this direction, but of course it is not enough in terms of the future reconciliation and conflict resolution. And last but not the least, in my view, there is a strong lack of coordination between Ukrainian authorities in terms of conflict resolution, especially judging from the perspective of the synchronization of actions between different branches, legislative and executive one. Still, the key issue here could be what could be or should be done in order to look into the future brokering peace, if I may put it as such, because the external factor in this conflict is a very strong one, and we have to take into account not only military dimension, but some other things which are not all of them new one for the expert society. So I will share just some of them. So first thing is the ongoing reforms should be carried out henceforward. in Ukraine, and the more reforms are carried out, the more support Ukraine should urge West and other allies to be given to Ukraine. And this is the key thing which would be beneficial for Ukrainian society and for backing Ukrainian institutions as such, and also undermining key Russian Federation narrative about crippled Ukraine, corrupt Ukraine. And because it is very sensitive in all other respects. Second thing is the think of the state policy towards non-government controlled areas. It should be engaging with the citizens who are residing on the other side of the conflict line. And that means that the issues which are the most sensitive for Ukrainians, namely the right to access to pensions or social benefits, could not be postponed or disregarded by Ukrainian government. So this is something very important to look at in the nearest future. Fourth thing, it is the coherent state policy of Ukraine in terms of sanctions. I mean, the domestic policy should be reviewed. The law on sanctions 2014 has not been amended so far, and there are a lot of loopholes in there. And on the other side, Ukraine should synchronize its state policy on sanctions together with its international actors. And supposedly a good option also could be adoption of the Magnitsky-alike Act into Ukrainian legal system in order to distribute a strong message to, that we are aligned with the international community and we are against such practices of Russian Federation in this case. And also, last but not the least, it is the thing of the divisions of between the Ukrainian society. I mean, the social cohesion is also a crucial issue to look at, since the polarized society is a very strong leverage which is used and utilized by the Russian Federation for the sake of this armed conflict. To conclude, I believe that transitional justice framework is obviously a belated response towards armed aggression of the Russian Federation, but still it is a right move in the right direction. Thank you.
Thank you very much, Taras. I think you gave us quite a sobering outlook, you know, to do a certain reality check against what Ukrainian policymakers like Anton and others who are trying to achieve something have to work on, because Ukraine has quite complex political landscape, you know, the disinformation, the toxic propaganda, internal infighting, more Kremlin-aligned groups, but also economic struggle right now. You know, frankly speaking, the impact of COVID on the occupied territories and in Crimea, you know, has its toll on the people's capacity to move across the line of contact, to access banks, to access services. So there's a lot on the table, and I'm sure there will be plenty of questions from our audience. So I don't want to take any more of your time from the discussion. There are two ways to ask the question. One is to type it in the chat function at the lower bar of Zoom, and you can see, just type chat, or if you click on participants icon, you will be able to raise hand. There's a little blue hand, and then I will be able to see your hands in the list of participants and give you a floor. So so far I don't see any raised hands, but I would like to, there's a question specifically to Anton and Taras from Oleg Martynenko. I don't know who Oleg Martynenko is, but if I will be giving you a floor introducing, please introduce yourself so that we know who you are and where you're coming from. And Oleg Martynenko is asking, how effective is donor support, presumably international donor support, to transitional justice strategy? Is it appropriate? Is it fitting for the current situation in your view? Maybe Anton, what kind of assistance are you getting, and is it fitting? And then Taras.
Well, I don't know. I'm maybe not the best person to answer this question because I work for the government. I don't.
You're not getting any technical assistance on,
so I
on
mean,
this topic?
Let me be clear. Yes. So the government is working as a government. So, right. But our working group is getting technical assistance from some international donors, and we are thankful for that. whether it's enough, I don't know. So we work with several particular international donors who assist both the big Commission on Legal Reform and who assist in particular our group, our working group, with our assignments. So yes, we do have the support, but I don't think that I'm the best person to analyze whether it's enough or not. But to those international donors who assist us, we are grateful, we are thankful, because yes, somebody assists us with communication strategy, somebody assists us with technical, administrative and technical work, secretary work, let's say. So yes, we do have this help, but I'm not the best person to.
Okay.
Of course, maybe it's always good to have more, but again, we are thankful for that organizations who assist us.
Okay, maybe Taras, how does it look from a civil society perspective?
Supposedly, I'm the proper person to answer and address this issue, since I'm in charge of Human Rights in Action program, which is implemented by the Ukrainian Helsinki Human Rights Union and supported financially by the USAID. To this end, I would like to emphasize that there is a wide array of donors working with the ramifications of the armed conflict in Ukraine, and USAID only is one of many. And of course, their contribution to the Ukraine's resilience towards armed conflict in Ukraine is very valuable. Of course, it's not enough, especially taking into account the human rights violations and abuses which are emanating from the armed conflict. And of course, I would put it in another way, that the donor support should not be a remedy in itself, since there is also a big stake of obligations on the state itself in order to address all the issues, despite all the difficulties which Ukraine is confronted with, because donors come and go, and this will be the situation where we would be in charge of our country and future. So I would desire more support, and I would urge more support from the international community, especially on the political level and diplomacy, but still it should be like a result-oriented process. So more for more.
Okay, I would like to bring in Kirsty with this question about strategic communication, and perhaps you could give some of your feedback from your experience working on conflict reconciliation and resolution. What are the most important things when planning such a strategy?
Yes, I think communication is key. The extra part on the story in Colombia was that after the signing in Cartagena, which was, by the way, very strongly supported internationally, so there were 13 presidents of Latin America at that signing, plus dignitaries from all over the world, plus the Secretary General of the UN, Ban Ki-moon. So it was very much a internationally supported affair, which was important. But days later, the referendum which had been put to the people about the peace accord, which the Colombian government had no doubt that it would win, the referendum resulted in the Colombian people rejecting the peace accord, and the rejection was by 50.2%. So it was a very narrow number. And they considered, the general feeling seemed to be, this is negotiation with terrorists. There are too many concessions to people who've committed atrocities. There was the statistics show that the majority of the people who voted against the peace accord were those probably least affected by the conflict in the urban areas. Those who were most affected by the conflict and had actually attended the victims groups and so on in Havana, they were all voted for the peace accord. So where you would get on communication there, those who were experiencing the violence in the middle of it wanted it to finish, even though they'd suffered a lot. those who were not as economically deprived perhaps and were removed from it and were in a situation of good communication, in fact, were the ones who rejected it. So I think with a communication strategy, you're always going to have to look at what your political situation is within the country. Colombia, for example, is a place that's very polarized. Other countries I've worked in, there is other difficulties with the news media being hijacked as to what is genuine, what isn't. And others are able to set up conversations on social media, WhatsApp groups and so on, to glean the facts. Within Colombia, for example, there was a lot of grassroots meetings going on. There were the NGOs played a really big part in actually keeping a hold and a grip on the facts to help disseminate the information. The second signing of the peace accord, which I was also at, then happened in November. And what the government did was, after the referendum, it went back to getting everyone around the table again and made some changes to the peace accord, but didn't put it back to the people. So at the time, quite interestingly, we'd had Brexit in the UK, and I was in Colombia experiencing the referendum. And I remember, in fact, I was interviewed by a lot of press, and I said at the time, this feels like Brexit, but in Colombia. It was quite an astonishing result, which nobody expected. But the Colombian government was interesting then, that they just simply didn't take it back to the people. Otherwise, it might have got stuck further.
Yeah. Thank you, Kirsty. I think it's interesting that Taras also mentioned the issue of social cohesion and how it's important, because in case of Ukraine, and of course those citizens living further away from the conflict in the west or center, they fear that the reintegration not properly done can jeopardize the European future of Ukraine reforms. And in a way, if it's again not done in a safe way, is perhaps better to keep it away than integrated on Kremlin's terms. So, you know, all these issues that, and I think it's interesting that you point, it's working with these populations that is so important, finding the way to address their grievances and perhaps present a strategy of how this could be overcome. But I'd like to move on around the table, so to speak, and ask the question from Craig Oliphant, who is addressing it to Anton and to Taras. How do you see the role in the process of reconciliation and transitional justice that could be played by the church? Because church in Ukraine is one of the most trusted institutions. Do you see the role for religious leaders, perhaps they're already doing something about it, but also in the context of this religious conflict with Russian Orthodox Church and Ukrainian Church getting independence? Could you unpack a little bit the religious factor in Ukraine? Maybe we start with Anton and then Taras.
Well, thank you for this question. We do think that church may play important role, and actually does play important role when we talk about the assistance to the detainees and to assistance to the political prisoners. So the church, actually different organizations, let's say religious, do this job and try to do this job both in Crimea and both in Donbass. So they also try to do this. They try to do this on the uncontrolled, on the territories which are not temporarily controlled by the government of Ukraine. So I do think that when we talk about the assistance to detainees and the assistance to political prisoners, church can and also of course prisoners of war, church can play important role. Also religious organizations do play important role when we talk about moral situation of Ukrainian soldiers and Ukrainian officers who are now fighting for our freedom on Donbass. So this assistance is very important. There are a lot of military chaplains inside the Ukrainian military brigades, platoons, regiments. This is a very, I would say, effective practice. So this assistance to Ukrainian armed forces other Ukrainian military formations like National Guard of Ukraine also. Of course, church plays very important role in this case. Thank you.
Yes, I do agree that the church should play a vital role in the resolution of conflict, but taking into account the realities within the religious situation in Ukraine, I do not believe that this is possible at all. I mean, the situation with Thomas, which is a bit jeopardized at the moment, and the situation with the Orthodox Church of Moscow Patriarchate, which is orchestrated by Moscow from abroad in order to push forward divisions between different religious groups in Ukraine, is also playing an integral part of the ongoing armed conflict in Ukraine. And one of the recent examples, of course, during the COVID time, the priests of the Orthodox Church, Moscow Patriarchate, they said, and they neglected all the restrictions which were endorsed by the Ukrainian government, in this sense, undermining all the actions which were addressed on combating COVID at that time. So, but history has a very good examples when church played a very consolidating role for Ukrainians. For example, you could refer to Ukrainian Greek Catholic Church during the World War II when they were saving Jews, and also it could be referred even to the Revolution of Dignity, where different confessions they were present at this Revolution of Dignity and fighting for better Ukraine.
Excellent. I'd like to now open the floor and give a floor to Katerina Busol. Katerina is a Bosch Fellow and actually an inspirer of this event. So Katerina, please.
Thank you very much to all of the speakers and to Orissa. And I actually got two questions, one to Kirsty and the second one to Anton. Kirsty, Colombia, as regards its relationship with the ICC, is actually at the same stage as Ukraine. There's the preliminary examination, and Colombia is known for having the longest preliminary examination, which lasts more than a decade. So what lesson do you think it gives to Ukraine and other conflict-affected countries? Does it mean that domestic proceedings are effective, or does it mean that there is such a amalgam or conundrum of domestic initiatives that they prevent the court from opening a full investigation? And the question to Anton is regarding the different parties who you think should be involved in the transitional justice process. It's a widespread belief in Ukraine that only the alleged victims should be able to contribute in basically building the narration about the conflict. But what other conflict-affected situations teach us, including the Colombia, that they involve the perpetrators also to tell the story, to build the narration, but also to negotiate the level of punishment. So as regards the Ukrainian context, do you think it should be more inclusive and include not just the victims, but also the perpetrators? Thank you.
Thank you. The ICC, I mean, your question is very perceptive in that the ICC will probably claim some success in Colombia, and that it would claim that it was the pressure from having a decade-plus preliminary examination in Colombia that assisted with ultimately with the peace process. However, many people have very different views as to the effectiveness at all of the ICC, and that it was simply kept at bay by the Colombian state, constantly setting up mechanisms to demonstrate that it was carrying out the prosecutions that it was obliged to carry out pursuant to the Rome Statute. Personally, I found within the civil society that Colombians, particularly those, my work has really been with sort of grassroots people who've suffered a huge amount, and they would take some comfort from the international, the international engagement, not only from the ICC, but also from the Inter-American Commission with precautionary measures and the Inter-American Court. So the international and regional mechanisms are really important with these countries where there is proven corruption and killing, with state infiltration. Colombia is very complicated with the infiltration between the narcos, the paramilitaries, the state, and the lack of governance in huge areas of the country where people then subsequently are completely massacred and have absolutely no rights. So I think it's got a supportive effect, the ICC, but whether it actually, from a legal perspective, had any other impact, I really would query that. So Ukraine could perhaps consider the ICC to have a supportive effect to ensure, looking at the justice part of its peace mechanism, that is compliant with international law.
Thank you very much. So don't put all your baskets on the eggs in the ICC basket. Basically, that's the gist of it.
I think so.
Thank you, Anton.
Well, first of all, let me briefly comment on this issue. Yes, of course, ICC is not an answer to all the questions. And of course, personally, I and a lot of my colleagues, we do believe that Ukraine should ratify the Rome Statute. And we do believe that the ICC, which is now conducting preliminary examination on the situation in Ukraine, shall move forward and shall open the fully fledged investigation of the situation in Ukraine, both in Crimea and Donbass. But we understand that homework is for us, that the biggest number of cases, the biggest number of trials shall be done domestically. That is why it's very important, A, to have appropriate legislation, in particular the relevant changes to the criminal code, which will in a proper way implement the provisions of international humanitarian and international criminal law. And B, of course, to have the national institutional capacity so that the Ukrainian law enforcement agencies shall know how to work with war crimes, crimes against humanity, and other gross human rights violations. And of course, ICC, we believe, shall step in, but in the cases where we do have the perpetrators, which Ukraine cannot get with our own hands, namely when they are situated on the temporarily occupied territories or in the Russian Federation or in third countries. So we do believe that ICC is very important for Ukraine, but in this case, in this situation, but of course, we need to do a lot of things by our own, as our home task, let's say so. I do think that trying to answer the question itself, I do think that we need to figure out one important thing. Colombia is an interesting example, an important example of transitional justice issues. But we do understand that Colombia is a classic non-international armed conflict. In our situation in Ukraine, we do have another issue. We have international armed conflict with the participation of the third state, of the Russian Federation. So answering maybe also a bit to Taras' idea, I have no problems in saying that Russian Federation is the occupying power and aggressor state. So easily, and this is my public position. In this case, it's even harder, because we need to reconcile with people who are now living on the temporarily occupied territories. I mean, we need to get them to Ukraine field, to get them feel as Ukrainian society. And this is done actually now. For instance, lately, several days ago, the Verkhovna Rada, the parliament, has adopted the law which enables all the children from the temporarily occupied territories to study in Ukrainian universities without any exams. So any Ukrainian child from Simferopol, Sevastopol, Donetsk, Lugansk can enter Kiev universities, Lviv universities, Odessa universities without any exams on the state budget form. So with paying no money for that. So this is, I think, the right things to reintegrate people, because we need the youth to be prepared and the youth to bring the ideas that Ukraine is a democratic state where human rights is a value, and so on and so forth. So we need to talk and to work with, let's say, ordinary people who are stuck in that situation and who reside on the temporary occupied territories, and we need to make all the best what we can in order to bring them to Ukrainian field, let's say, to make them feel as part of Ukrainian society. Of course, we need to also think of the Russian Federation's role and the Russian Federation responsibility for all that Russian Federation has done. And actually, this is now also being done by the state of Ukraine, namely the court, the use of international fora, international courts, different ones, ICJ, ICC, Tribunal on the Law of the Sea, PCA, in order to get this portfolio of cases. And I'm sure there will be success stories in these cases. So this is, I think, how it will move on. Though, of course, for transitional justice, this is not a common issue that we have IAC, International Armed Conflict and Transitional Justice, but this is a reality what we have now. So on the one hand, we need to apply transitional justice mechanisms in order to reconcile and reintegrate. And on the other hand, we need to use and apply international responsibility mechanisms for bringing the aggressor state, the Russian Federation, to responsibility. Hard task, but we need to move forward with it.
What about the question about the narrative of perpetrators, the second question that Katerina asked?
Sorry, yes, sorry, because it's a complex issue in our minds. Lately, one of the journalists asked me whether there can be a monument in Ukraine built for Givi or Motorola, which are the most prominent examples of war criminals when we talk about armed conflict in Donbass. My answer, of course, was no, because they are war criminals. So there cannot be anything in order to commemorate them. So when we talk about perpetrators, and it is the story that on the other hand, on the hand of the Russian Federation and on the hand of the organized armed groups which are controlled by the Russian Federations, which are under effective control of the Russian Federation. The leadership of Russian Federation and of these groups are really war criminals. I mean, they killed civilians, they tortured people, they persecute Crimean Tatars and the Ukrainian activists in Crimea. So what negotiations and how they can be included into this reconciliation, I don't see the possible ways. Because again, when we look both in Crimea and Donbass, all that people, they are pretty much all of them war criminals who committed very serious human rights violations.
Okay, I would like to also ask the question to all. It's kind of, I think this question comes to many minds, and perhaps it came across already to some extent, but maybe each of you could answer it again briefly, because it comes from Jakob Hotter and also built on Marina Ambrozak's question. To what extent is it possible to implement a transitional justice framework as long as Russia denies that it is part of the international armed conflict and refuses to cooperate? What would you say to that? Taras, we'll start from you.
Definitely the external factor is a very powerful one in terms of the ongoing armed conflict, and especially when we take into account the Minsk process, which is currently an impasse due to the fact that Russian Federation is steering this armed conflict. And of course, this does not preclude the failure of future transitional justice. I mean that some elements of transitional justice could be implemented within the domestic domain of the Ukrainian society and could be beneficial for the Ukrainian citizens. And this is the strongest message we could distribute. Of course, we could not seek the maximum out of the situation, but minimum is our obligation.
Thank you, Taras. Kirsty, what would you say?
It's very difficult. I'm not an expert on Ukraine and Russia, but obviously Russia is denying being at war. So you've got a very difficult starting point. However, I think you can draw a lot of parallels, looking at other transitional justice mechanisms. So quite often the state, I'll use Colombia as an example because that's the one which is the massive peace process ongoing at the moment. There we had the conflict still raging whilst the peace process was happening, and that was criticized by a lot of people. So the Colombian army would be bombing the camps of the FARC at times. There would be massive fights going on with killings, and many of the human rights lawyers in particular was, how can you even start to talk about having a peace process when you're having this ongoing? However, that's what happened, and the Colombian state considered that it had to keep some form of aggression. So they were not accepting, frankly, their position at the table for quite a long time, but progress was still made behind the scenes. So a lot depends what's going on diplomatically. However, you also need other countries, I really consider, to assist diplomatically. Colombia had a lot of assistance behind the scenes from other countries that had gone through really serious conflicts, actually including from Northern Ireland, and with politicians from all over the world assisting to try and keep it on track. So I think you need that political will internationally. And also the other point I would make is that you certainly can try and get some reparation. Now, some of that might be simply evidence gathering before it's all destroyed. So, and we can see that ongoing, for example, in Syria. So there are all sorts of different parts of a transitional justice mechanism that can be considered when looking at Ukraine, even if you're not necessarily going to get the state in the position you want it to be in.
Okay, Anton?
Well, of course, I would say that in our situation, the assistance of international society, international community is very important, because we do understand that we are in a situation when we really face the challenges of the foreign aggression. And when we have these two very difficult situations in Crimea and in Donbass, actually, which is a big one story. So actually, we do understand that this is not a divided, separate issues. That this is the issue which is a one story, but of course, which are very hard to work on. And of course, I mean, we need to look at the experience of foreign states, how they face these issues. But we need to take into account the role of the third state of the Russian Federation in this. And of course, when we try to answer the question how to talk and how to work on transitional justice when the Russian Federation denies its participation, at least in Donbass, you know, I'm sure that we are right. I mean, Ukrainian state and Ukrainian experts, civil society organizations, we are right that we work now on transitional justice issues, even though the conflict is not over. But I'm sure that we need to be ready with the answers when the conflict is over. So it's better to be prepared when it's all still ongoing, in order when there is the ceasefire or whatever, we are ready with the receipt how to move forward. So I'm sure that we are now on the right path in delivering and trying to deliver transitional justice answers in order to be ready.
Great. Taras, before you start answering this question, I would like to connect it a little bit to what Solomia Borshosh has asked about different perceptions in the society. Overall, of course, Ukrainians see Russia as an aggressor state, but in some regions, for example, she says in the city of Mariupol, citizens do not consider Russia to be an aggressor or party to the conflict. So the question would be, how successful will the transitional justice process be in establishing the truth in this case? So a bit complicated, but how about you give it a try?
Yeah, I do agree that this is a very complicated, sophisticated issue, especially in terms of Ukraine statehood, let's put it in this way, because it's confronted with armed aggression and hybrid warfare, and also lawfare, which was not mentioned today, when the Russian Federation is denying application of international humanitarian law and instead inviting Ukraine to accede to its national legislation. So I do not have one clear-cut answer in terms of the divisions and perceptions which indeed exist in terms of Ukrainian society, and it has some other even stronger emanations, alas. For example, the political preferences of Ukrainians. The political party of opposition bloc, who is now currently in parliament, is completely antagonistic, and it is supporting the agenda of the Russian Federation in this country. So, and as well the media, as in the way they are disseminating information and depicting this armed conflict in the eyes of Ukrainians who are consuming the information largely from the mass media who are owned by oligarchs. So there is still a lot of homework on the side of Ukraine in order to address all these issues, because they do not mean not only the end of the conflict, but Ukraine's future resilience to any threat.
Thank you very much. We'll take a few more questions. We still have 7 minutes. This one is from Irina Brunyova-Kaltserska, from, I think, one of the mediators working in Kiev, to Mr. Anton Koronevich. Would you see an opportunity to include mediation, dialogue facilitation, or restorative justice into Ukraine's transitional justice model?
Yes, I see this possibility, and I think that this is very important to have this dialogue with our Ukrainian citizens who are stuck on that territories and who want to be part of Ukrainian society. So I do believe that dialogue platforms are important. But let me make a disclaimer that this is not about dialogue with war criminals. Yes, but this is dialogue which means a reconciliation and reintegration. But again, even that I need to make now this disclaimer, this shows how important it is to communicate in a proper way all these issues to Ukrainian society. So yes, dialogue platforms, we know that some dialogue platforms work now on these issues, on these matters. We do have like cooperation with them. I mean, we do get the information from them, but yeah, this is, I would say, something not very public things. But we do believe that the dialogue is important.
And there was also a question regarding the kinds of civil society organizations that are part of the your working group on the transitional justice. Can you give a little bit an idea who these groups are and who are members from civil society that contribute?
Yes, sure. The only issue, I don't want to make an insult to other colleagues with whom we also coordinate. So, I mean, yes, we do have members of our working groups who do represent civil society organizations. They are from Ukrainian Helsinki Human Rights Union, Regional Center for Human Rights, organization Group of Plivu, organization as Human Rights Center Zmina. I'm afraid I can forget about somebody, so please don't consider this as an insult. But what is more important is that even though there are several members of civil society organizations inside our group, we do cooperate with many more organizations who are not members of the group. So we have no problems in let's say, cooperation with other civil society organizations and coordinating with them even if they are not members of the group. Ukrainian Legal Advisory Group is also inside our working group. So the representation of civil society is important and is rather, I would say, representative in our working group. This is not 1 or 2 members. This is, let's say, 30 or 40% of the members of the working group.
Excellent, thank you very much. And I have a question from Stefan Siohan from the Le Figaro and Radio France. He's particularly asking about the case that was opened against Girkin Strelkov, who was one of the Russian paramilitary fighters that started the whole, he was involved in the annexation of Crimea, later on in the armed operations in the Donbass. The prosecution was initiated in 2014 for his war crimes committed in Slovyansk. And the journalist is asking, are there any new charges against Strelkov? What is the status of that case?
Well, of course, this question ideally shall go to the Office of Prosecutor General's Office of Ukraine, namely to the department which deals with the crimes committed during the armed conflict, which was established actually in December 2019. So this is also very important endeavor that inside the Office of the Prosecutor General, we have a special department now which deals with crimes committed during armed conflict. Igor Girkin Strelkov is one of the most well-known war criminals of the Russian Federation. He committed a lot of war crimes, in particular the illegal killings, unlawful killings, the so-called Troika, when he with 2 his fellows had made decisions to kill persons and considered this a court in Slavyansk. The so-called Stalinskaya Troika, this was a decree of Stalin of 1943 or something like that. So you can imagine all the idiotism of the situation which Russian Federation brought to our Ukrainian land. So this case is investigated, and I'm sure that there will be the result.
Mm-hmm. Taras, maybe you can say how people like that are perceived, or what do you think should be the right response? So Ukraine is doing already the right things with regards to criminals like Girkin.
I think that the proper stance to view the situation in terms of the options whether to be a part of the Russian world with its lethal and poisonous methods, or to be a part of civilized world. So this is the key issue in this armed conflict. And it's not only about the Ukraine, it's a bigger issue.
Thank you. Kirsty, perhaps before we close out, maybe you have some reflections or feedback that you want to share.
Yes, on dialogue, obviously many people in Colombia considered that those in negotiation were war criminals. And yet that was the only way that any progress could be made. So I was sort of interested with that red line of, yes, dialogue, but not with war criminals. Who are you saying is a war criminal, first of all? So, for example, ex-President Uribe was very against the peace process by Santos, and he considered that Timoshenko was a war criminal in the negotiation in Havana. Last year, one of the former lead negotiator in Cuba has rearmed and rejoined up with the FARC, and he complained that not sufficient was being done by the state to stop the murder of former FARC combatants, and the state was complaining that he had not fulfilled his promise in revealing sufficiently where there were minefields. But this is the kind of plane that both state and FARC were operating on, with real grave crimes and crimes against humanity being carried out. The other point I would make in terms of where you're going with a justice and a prosecution mechanism is that countries like Colombia have tried it many times and failed, and tried again. In 2005, in fact, they had a justice and peace mechanism, which again, they have a model of going for much lighter sentences. And they point to the success of the justice and peace mechanism, which again is quite controversial. And that involved the trial of paramilitary groups and the disarming paramilitary groups, and then the trial of them, the AUC paramilitaries. And they point to that 470 of those combatants received sentences, were convicted, received sentences, and they compare that to tribunals like the ICTY and the equivalent tribunal for Rwanda, and look at the number of people, in fact, who were brought before a justice mechanism under something like the Justice and Peace mechanism, and they consider that much more successful than something like the ICTY or the Rwanda tribunal.
Well, thank you very much. Thank you for giving us some of the cautionary messages, some of this update on what is happening right now in Ukraine. Ladies and gentlemen, I will be closing the first seminar because we will be reconvening tomorrow. And this is something I would like to remind you that tomorrow at 10 a.m. London time, we will have a second session on transitional justice, focusing on amnesties and truth-telling formats. But before we close, I would like to extend the gratitude to all our speakers who joined today, who shared their experiences, answered so many questions from our audience. Kirsty, Anton, Taras, thank you very much for being with us. We will be releasing the video. We will also be meeting tomorrow. And thank you to Katerina Busol for really making sure this event happens today. Thank you very much. Stay well, and hope to see you tomorrow. All the best.
Thank you very much.
Thank you.
Thank you very much. Bye-bye.
Bye.
Bye-bye.
Thank you.
Thank you.